Hello, I'm Jodi Ginsberg of Ginsberg Law Offices, and today I'd like to talk to you a little bit about giving proper notice under the Georgia workers' compensation laws in the state of Georgia. Obviously, when you get hurt at work, it's very upsetting. You're injured, you're in pain, and you also are wondering, should I tell my supervisor or shouldn't I? Am I going to lose my job if I report my injury? The bottom line is it's extremely important that you give notice to a supervisor or manager within 30 days of the date of accident. I always tell clients, report the injury as soon as it happens. Don't go home first. Don't spend the weekend at home trying to get better. Give notice. Even if it's that very minute, that is what's going to help you in the long run. While we understand that you are concerned about your boss thinking that it may impact your job, or you thinking it may impact your job, the fact of the matter is they will hold it against you if you don't report it right away, thinking that you've gone home and perhaps injured yourself picking up your children, playing basketball, going to the grocery store, etc. So the first important thing is that you give notice immediately. It's always best to put it in writing if at all possible, and keep a copy of the notice, written notice, that you've given your supervisor. Telling your coworkers, your friends, your spouse, and your family does not satisfy notice. It must be reported to a supervisor or manager. Writing it down and handing it in and keeping a copy on the incident report is extremely important for you to show that in fact you gave notice in a timely manner. If you're unable to write it down, then at least phoning it in if you have to go home first. But again, telling the folks in person is the best route that you should follow. Now, we have many people call us and say, well, I really did not want to give notice right away. Based on what I told you earlier, they were concerned about losing their job. So they don't report their injury, and they go home, and perhaps they go and see their own family doctor or go to the emergency room and pay for it out of their pocket or with group insurance. That is not a good idea. Not reporting your injury to your employee and not seeking medical care under workers' compensation can come back and haunt you. Going to the doctor on your own and paying for it out of your pocket or with group health insurance is never a good idea. First of all, it's very important that you speak with a workers' compensation representative or supervisor so that you are given proper information on where you're supposed to seek medical care after you give proper notice. Telling your private doctor that you got hurt at work is certainly one way of having some evidence that indeed you got hurt at work. But again, that's your own self-reporting. And while we can use that as evidence, it is not the very best evidence. Notice must initially be given to your supervisor or manager. Seeking medical care thereafter, if they have a valid posted panel of physicians, is the route to take. If they do not have a valid posted panel of physicians, which means 6 doctors on a list, posted where you can see it and where it's explained to you, then you can in fact go off and see your own doctor. But that does get complicated because the insurance company and the employer are not going to want to pay for your own doctor's care. But looping that into proper notice is something where we can say, yes, that person did seek care, that person did give a history of being injured at work that day, the day before, etc. And using that also as notice where you can take that back to your employer and say, look, I had to seek medical care at 3 o'clock in the morning, my back was killing me, my shoulder, my knee, and I got hurt at work and I gave that information to this doctor and now I'm giving it to you. So that is sort of another way that notice can be given if you don't support it right away and speak with your supervisor. But like I said, taking care of that notice requirement as soon as that injury occurs is very important. Now, some folks question what date of accident when they have a repetitive type injury. It's pretty obvious if you should get hurt in falling off a ladder at work, if you should get hurt while unloading a pallet off the back of a truck. I mean, you know, you bent over, you pick something up, and you hurt your back right on that day. It's something else when you have a repetitive motion type of injury, where you type a good amount, or you're doing repetitive type of loading and unloading and you hurt your wrists, your hands, or maybe even your shoulder. But it doesn't dawn on you, maybe on that very day, that it's because of my work. So how do you come to figure out what is the proper date of injury and when does that 30 days of notice run? It's a very important question. It's always important to think about when is the first time I realized that I had that particular problem, and did I give my employer proper notice at the time? If 30 days should pass from the time, let's say, you went to see your own doctor, didn't realize it was a work-related injury, and you have now waited more than 30 days to report that injury, you're going to find yourself in a very difficult position, because the insurance company and the employer can raise the fact that you did not give timely notice. So like I said, it is extremely important when and if you realize that you've been hurt at work, you immediately give written, the best way to do it, notice to your employer, your supervisor, your manager, or oral, meaning verbal notice, speaking with them immediately and confirming a date and a time and who you spoke to, and then proceeding. If you have questions about proper notice, if you have questions about the timeliness of your notice, if you have questions about whether or not you have filed notice with your employer properly in the state of Georgia, we are always here to help, and you are certainly welcome to call our law firm.